The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Good afternoon. We have three cases that will be submitted this afternoon. The first case is State of Iowa versus Christopher Brown. The second case is Tennis Den Hartog and others versus City of Waterloo. And the final case is State of Iowa versus Robert Du Bois. Those last two cases are now submitted to the court without an oral argument, and will proceed to hear the arguments in State versus Brown. Ms. Phelps.
Thank you, Your Honor. May it please the court, I'm Lauren Phelps. Counsel, we're here today asking the court to draw a clearer line between state action and private action when that action is done by a police officer. At this point, it's our belief that the line is not all that clear, and we're asking the court, when that line is drawn, to determine that Officer Kilberg, Christopher Brown's stepfather, stepped over the line into state action. The situation here was that Officer Kilberg is a stepfather to Christopher Brown. He's lived with him since he was about 3 years old. Christopher was 20, an adult at the time of the first incident on February 5th. He was living outside of the Kilberg's home and appears to have been driving a car which was not owned by his mother and stepfather. The family got wind of the fact that they believed that Christopher had taken a gun from a relative's house, and Christopher's mother, being concerned, decided she was going to go and confront Christopher along with a couple of other relatives. Officer Kilberg made the decision to go along. We wouldn't be here today if Officer Kilberg had gone along and stood back and let Christopher's mother handle it and just made sure that the peace was kept, didn't interfere unless things got out of hand. That's not what happened. Instead, they arrived close to Christopher's apartment. Officer Kilberg stood out in the street, raised his hand, ordered his stepson to stop. He yelled at it, he admits it, used profanity, and the young man pulled over.
Does that evidence indicate state action?
Probably not if that was all that he did. But he goes on. He opens the door. He takes Christopher's bag out of the back seat, puts it near him. He then decides that there's a knife under Christopher or on the floor. He takes his knife, and then even before that, he orders him to place his hands on the steering wheel. And when he attempts to move, he tells him, put your hands back on the steering wheel. We're getting much closer to state action now. This is not the action of a parent toward a grown child. This is not an 17-year-old. It's a grown man.
What if Officer Kilberg, instead of being off duty, was retired and did the same thing? Because that's what he's used to doing. I mean, would that be state action?
That's an interesting question, and I will admit it, I haven't researched what would happen if he was retired. The fact is, if he was retired, I don't believe, and correct me if I'm wrong, I don't believe that he would then have the authority to make an arrest as a police officer. In this case, he was within his jurisdiction. He had the authority to make a stop and an arrest.
What does the record show that whether or not your client was responding to him because he was a police officer or because he was a stepdad?
As with most records of these sorts of things, there are certainly arguments on both sides. But the facts are that he Officer Kilberg testified that when I give an order, I expect it to be followed.
What did your client testify? Was he obeying a police officer, or was he obeying his stepfather?
Don't believe he testified to that. I don't think that's in the record. Officer Kilberg did testify he wasn't freed to leave. He wouldn't have allowed him to leave. He also did a full pat-down search and frisk with Christopher's arms either behind his head or on the car, at which point he found the gun. There's a number of different cases with...
Maybe, what can,
Yeah.
we've talked about a continuum, and you said we're sort of following down this continuum where it now converts to state action, I think is your position. Where in this continuum does he now cross the line and become a state actor?
Well, certainly when he decides that Christopher is not free to leave, that is the action of a police officer, not a concerned parent. In fact, he enforced that. In fact, he also took possession of evidence. That is another one of the marks of state action. In the various cases that the state cites, I'm going to say Walker and another here. One of the issues is whether, there's two issues that are really important here. First is whether the individual has a legitimate private concern that he's working for. And the cases in which the courts have found no state action have been cases where the police officer was working and found things in the course of his job. For instance, a security officer who finds contraband. Mine went blank. Get back to that one. On the other hand, cases where they found that it was state action is where the officer was doing something that was not related to finding the contraband. For instance, an exterminator exterminating a house who took possession of marijuana as evidence and gave it to the police. That's not state action. Nothing about being an exterminator requires taking things, or even allows taking things out of somebody's house.
What difference does the fact your client's age 20 make? Would it be a different case if he were 16 or 14?
Well, parents who are young, parents of minors, obviously do have both a right and a duty to control their children in certain ways. So yes, I think it would very much so. The fact that if you have a 16-year-old who has a car, first of all, it's probably licensed, probably on your insurance. You probably have financial ownership in some way of that car, and you have the right to control your child's behavior. Unfortunately, I think that all goes away when they turn 18. At that point, we have an obligation to deal with our children as adults, because they are.
Really? I mean, so we have a 20-year-old who's got a gun, a loaded gun, a stolen loaded gun, and assuming this officer was not an officer, let's assume he was a state worker or a teacher or anything else, and his 20-year-old son had a loaded gun and he found the loaded gun on him. You don't think he'd seize a loaded gun from a 20-year-old?
Sure, because, well, it depends on whether it depends on a whole lot of things, Your Honor. Was he threatening him with the loaded gun? Did the 20-year-old have a permit for the gun? All those things come into play.
Well, what about the facts here? I mean, I like to go with the facts that we have here, which is that he's apparently stolen the gun from his uncle and is now in possession of this loaded 9mm gun, and they also have concerns that he's suicidal. So I'm struggling a little bit with the continuum that I'm on this little hang up here today, but the continuum of when everything that this person may have done shifted from a private concern about his stepson to more of a governmental entity. I'm just trying to find that line again.
That's a good point, Your Honor. The fact of the matter is the record shows that the stepmother had had concerns about the child being depressed in the past. The issue of being suicidal actually came up as a result of a specific question about whether he thought he might be suicidal, if I
Oh, but
recall
then-
correctly.
I thought the record reflected as well that they were meeting as a family. I mean, they were primarily just trying to get the gun back, and then they were also looking into some type of civil commitment for him because he was also abusing, or they suspected that he was abusing substances that he shouldn't be, and that was all part of this equation, wasn't it?
Absolutely. And Officer Kilberg certainly would have been well within his rights to file a civil commitment petition. He apparently decided that he didn't want to do that. He wanted to handle the matter himself. And so he proceeded to not only find the evidence, and this is important because removing evidence is one of the hallmarks of state action. In the case law that I have found, it's pretty consistent that officers who find the contraband in the course of a legitimate enterprise in a place where they have permission to be and call the cops, and then the cops get a search warrant based on their statements, that it's not state action. But here he took it, actually both on the 5th of February and the 21st of February. He took the marijuana and the other contraband, took possession of it. On the 21st, he actually broke into his stepson's car. He opened it, and then he took out the back seat, which goes well beyond anything a police officer can do without a warrant.
At what point in this stop did your client need to get his Miranda rights, if this was state action?
Before he made any statements. And I don't believe any statements were actually made that were used until he was in the police car with a different officer, who I believe did give him his Miranda rights.
Isn't this a lot different than, say, State v. Carter, where the Vets Auditorium hires off-duty Des Moines police officers who are in uniform, carrying guns, wearing badges, and they're working security? That's a lot clearer case of state action than here. We have a stepfather searching his stepson's car.
It is a lot different case. And, you know, that's one of the reasons it's important, because we do expect and appreciate police officers working security for finding contraband and calling off uniformed officers to come and get it or taking action. In this case, though, it's much more like the caretaker on property, and I believe it was State versus Walker, who's wandering around the property, sees a marijuana plant inside the guy's house, and decides to break in and search. Or maybe he has a key, but he goes in and searches without permission. This is not a case, especially on February 21st, where there's any indication at all that this officer had permission to go into that car, and certainly not into the trunk through the back seat. If he's not acting as a police officer, that's pretty much a definition, just pretty much a textbook burglary. You
I'm
go
still
into a car.
I'm still just having a little bit of a disconnect here, and that if my 20-year-old son or daughter's home from college and I suspect that they're using marijuana, and my wife tells me, you know, even as a lawyer, an officer of the court, and she says, you know, I looked in the car, because she did get in the car herself and didn't find anything, and then he didn't really break into the car. She says, you go look, you know, I think he's using again, and dealing drugs again. You know, if my wife tells me to go in and look at my son's car, in my driveway, I'm probably going to go in and look at it. And how does that mere fact that he's a police officer change the fact? I'm just telling you, I'm going to go into my child's trunk if I can flip up the back seat. They all have fold-down back seats now to access the trunk. It's not like it's a big break-in. I'm probably going to go ahead and do that. So why is the action that this guy took any different by the mere fact that he's a peace officer?
Well, first of all, it doesn't meet the criteria of being a legitimate private action, because breaking into somebody else's car, even your son's, even for a good purpose, is not a legitimate private action. Just as if you're the child, driving off with your parents' car without permission and rolling it is not, the kids get charged with theft every day for that kind of behavior. They usually plead down, but there's no question it's either theft or operating without owner's consent when a child takes a parent's car. I think the overall principle here is that officers' authority and the authority they use based on the fact that they are an officer has to match the responsibility they take for still honoring the laws when they use that authority.
At the end of the day, doesn't your argument boil down to if you're happen to be a cop, you have fewer prerogatives as a parent than other citizens would have?
I don't think so. Quite frankly, I don't think that parents of 20-year-old children have the right to take possession of their children's things, cell phones, packages, without permission, any more than children have the right to take their parents' things without permission.
But is that, I don't know about the right, but is that really the issue? Isn't the question whether a reasonable parent would take those kind of steps, come what may? I mean, when we're talking about loaded guns, stolen guns. How many parents are going to think of the niceties of whether, kind of breaking into a car is going to be an offense when there's a loaded stolen gun around involving a youngster who may have mental health problems?
While I appreciate that point, the standard isn't whether a reasonable parent would do it. Because here's the thing, a reasonable parent would not have the skills and abilities to do what Officer Kilberg did. He wouldn't have the ability to order his son out of the car and conduct a police-style pat-down search. It's very similar to the case of the ranger who went and found a rolled car while he was off duty. Rolled or stopped anyway. Took the guy out of the car and told him to sit in his car. And the car had warden, park ranger, whatever, on the side of it. And that's state action. It's pretty clear. In this case, within the family, Officer Kilberg always has the equivalent of that label on the side of the car. I'm a police officer. Chris knew it. And certainly he was influenced by that. My experience with 20-year-old children is that in the normal course of events, you put your hands on them, you tell them to do something, and they're still at that stage where instead of complying, they're going to do just the opposite. So it might be a reasonable thing for a parent to do, but it isn't a reasonable thing for a police officer to do. Permission to continue?
You may sum up.
Okay. In summary, it's important that the law balance a police officer's authority and the way he uses it with the responsibility to uphold the laws of this country, not to, as it was the case here, avoid them. This is a search where Officer Kilberg admitted he knew he didn't have enough for a search warrant. So he wants to hide behind, I was a private person, and that's not right. Thank you.
Ms. Phelps, thank you as well. Ms. Reinkoester, you may present your argument.
May it please the court, counsel. I'm going to start just by reframing the end of counselor's argument in terms of whether someone would have a legitimate private action if they acted unreasonably, or whether a parent has a right to search a child at any age. And I just think that that's the incorrect inquiry here, because it's well established that the Fourth Amendment only applies to the actions of government officials. It does not apply to private actions, even if those private actions are manifestly unreasonable or break the law, it still does not prescribe those particular actions. So whether the parent had a right or not isn't necessarily the proper inquiry for this particular case. And from a legal standpoint, the facts of this case are somewhat uncommon, but it is a situation factually that most, if not all, parents know well, which is that when you have a child who is acting against his best interests, and in this case, a child who is troubled and depressed and stated at his sentencing that he suffers from depression and anxiety, who has inexplicably taken a gun, do you just stand back and hope that the best that the best thing happens, or do you take swift actions and intervene to prevent your child from harm, either harming himself or harming other people? And this is precisely the situation that was faced by Lynn and Brent Kilberg, who in this case acted like deeply concerned parents when they searched their son. And I also want to emphasize the role of Lynn Kilberg in this case. I think that that has been vastly overlooked by the defendant in emphasizing that Brent Kilberg was the actor here. Lynn Kilberg was the one who informed her husband that her son had stolen a gun. And she was the one who told him they were all meeting at defendant's apartment. And he met them there. She also motioned for him to move to the side of the road. She also approached his car. She also saw the flash of silver at his hip. She also ordered him out of the car. And it's worth noting that she's the one who asked her husband to conduct the pat-down search in this case.
If Mr. Kilberg was assaulted during this confrontation, could the perpetrator be tried or convicted? Convicted is probably a better word, of assault of a police officer?
I don't think that Chris Brown could have been tried or convicted of assault on a police officer in this case, because I think that the interactions here would kind of cut both ways, that this was a family interaction, and that if he had assaulted him in the course of that it would have just been a typical assault. You know, if this was a stranger in this situation, I think it would come down to whether that person had knowledge that that Officer Kilberg was, in fact, a police officer. Of course, that is a little bit different in this case because clearly his son knows that he's a police officer, but he wasn't responding to him as a police officer. And I don't think the record supports that his responses were anything other than a son in this case. So one of the other...
Counsel, it strikes me that we're looking at an objective test here. Maybe I'm wrong on that, but that's the way I'm viewing it. In the first occurrence, he steps into the street. He's conducting himself as a police officer would act had his uniform on, right?
I disagree.
Steps into the street, stops the car, directs the driver to put his hands on the wheel, not to move, starts retrieving the evidence from the car, and then, like any other police officer, proceeds to deliver that evidence to the state to use in a prosecution. Now, all of those circumstances, those facts and circumstances, look to me like the conduct of a police officer. And so why doesn't that rise to the level of state activity?
Okay,
Is it just because he wasn't on duty? Is that the sole consideration we need to look at?
No, it's not the sole consideration, because there are certainly circumstances where an off-duty officer's actions could convert the encounter into state action. And I'll respond to all three.
Under what circumstances might that happen in your construct?
Well, it's a little bit more difficult in this case because this is a very unique situation in terms of a family relationship. But if we were talking about an off-duty officer who encountered a stranger who was committing a crime, I think that there are certain outward indicia that could show that he was acting as a state actor, such as, let's say you're off duty and you're still wearing your uniform and you have your gun and your badge, and someone steals something in front of you and you pull out your gun and you say, "Stop, police," I mean, at that point, you can probably make a good argument that that has been converted into state action. Now, there could be varying levels of that. If someone's not wearing their uniform or not carrying a gun, they don't identify themselves as a police officer, which is a factor that's been considered in a lot of these cases where officers work as off-duty security guards. And a lot of the cases where they've only identified themselves as a security guard and aren't wearing their uniforms, it's still considered private action. So in terms of your first question, in stepping in front of the car, I actually disagree from my reading of the record that this would be considered a typical response by a police officer. I actually think that if a police officer had knowledge that a depressed and suicidal person had a gun and was driving down the street, the officer probably wouldn't step in front of the car. You know, that seems to be very dangerous. I think that this is instead an emotional response to somebody that you know will stop the car. And the number one priority here for his parents was to detain him, get this gun away from him because they didn't know what he was going to do with it, and then get him help. So in terms of what you called collecting evidence, I also don't think that that's particularly collecting evidence in this case. I think that they were very concerned that he was going to harm himself, and their number one priority was to get weapons away from him, and so he couldn't use them to harm himself. And I think that's especially true when you see that when they found all of the weapons, they returned the gun to the uncle who put it in his car. This wasn't we found all of this and we turned it into the police. But even speaking to that, the factor of...
What about the marijuana, though? Lynn seizes the marijuana, and almost immediately, once the stepdad came in, they decided they needed to call the sheriff.
Well, they had a family conference first, actually. They called Chris Brown's biological father on the phone, and they all discussed what they should do next. But I think that in the cases that I've cited in my brief, you will see that the fact that you have evidence of a crime that is turned over to the police is actually a factor that cuts away from government action. Because if Officer Kilberg actually believed or actually was acting in his official capacity, he himself would most likely seize the evidence, take it to the police station, arrest his son. That's what an officer does when they believe that they are acting in their official capacity. What a private citizen does when they encounter illegal evidence is call the police, tell them what they found, and turn over the evidence. And I think that...
How important is what Mr. Kilberg thought? You just talked about his subjective thinking or his intention. Is that a significant factor in our analysis?
I'm not sure I would say that it's a significant factor, but I would say that the cases that I've outlined in my brief and most of the cases that I've read on this subject do consider the subjective state of mind of the officer in these unique circumstances as part of the elements or factors to be considered in the totality of the circumstances. I do think that this is still mostly an objective test, and I think it's an objective test that's partially informed by the subjective intent of the officer. But every case that I've read about these circumstances, the court does factor in what the officer testified his subjective motivations were for it.
Can you be searching as a parent in a private action and then seize and continue to seize property as a parent in state action?
Is the parent in this situation a private citizen, or are they also a government official in their daily lives?
Well, can you transform into, while the Fourth Amendment is providing protections, can you transform from a private citizen into a state action?
No, I haven't seen any indication of that in the case law where a private citizen can turn themselves into a government actor. I think there might be situations where if someone, almost like a confidential informant or an informant situation, where someone could be converted into an agent of the police if the police know and are acquiescing to or aiding in the person collecting the evidence. If this is just a parent who's walking into their child's room every week and let's say they have a very bad child and they're always collecting a joint. Well, I mean, it isn't you collected 12 joints, you're now a police officer. It's just, you know, those are
Well, but
always going to be.
I guess I maybe disagree with that. Couldn't there become a time in this case when they do discover the marijuana and everything was going to be handled as a family matter up until the discovery of the marijuana, and then the officer, the stepfather in this case, said, now I can't just let this thing go. I have to report it to the police. But he could have, he didn't in this case, I don't believe, but don't you think he could have at that immediate time, even if he's off duty, he could have converted that to a government action if he said, okay, son, I'm sorry, we can't handle this informally anymore. I can't let this go. I'm hereby arresting you and seizing the property. Couldn't that convert him into it?
Yes.
I mean, it didn't happen here.
Right.
But
I think that
I'm
would.
not saying that it could never happen or convert into that, but don't you agree that could happen?
I agree that could happen,
Okay.
and I agree it didn't happen here. But that possibly could happen. Maybe I misunderstood the question in terms of whether the person was a government official or not. I mean, that would certainly play into the analysis here. There are certainly circumstances where something can start as a private search if you're an off-duty officer and be converted into a government search. And I actually think that there's a case that is on point with that in State v. Woods, where an off-duty officer who was providing private security for a landowner went into the house with his permission and found some evidence of drug use. Instead of immediately reporting it, he continued to come back 3 or 4 times and collect further evidence. And at that point, his action was converted into state action. He also at some point went to the police and said what he was finding, and so worked in concert with them. So it possibly can be converted. Just not under the circumstances of this case, which really indicate that he was only operating as a parent.
If we hold that Officer Kilberg crossed the line in this case, to follow up on Justice Mansfield's question to your opposing counsel, are we going to, in effect, impose restrictions on police officer parents that other parents don't have?
I believe so. I believe this would put police officer families into a unique category that is separate from all other families, because it would require the officers to always be sort of treading the line between official duties and parental duties, and it would really hamper their ability to be a good parent to their child if they were always worried that they possibly could be crossing the line, which is something that all other parents don't have to worry about. And that's something that that's something could extend to other state actors, including myself. If I was always operating in my official duties, that could hamper my ability to parent, or there could be other implications in terms of creating special categories of parents simply because their day job is being a police officer. If the court doesn't have any further questions, I would ask that you affirm. Thank you.
Thank you as well, Ms. Reinkoester. Ms. Phelps, you may present your rebuttal argument.
Well, where to start? First of all, this needs to be an objective test because it needs to be something that police officers and individuals can't know what they can and can't do. As to intent, my recollection is that intent can be inferred from actions. And as was pointed out, Officer Kilberg's actions were those of a police officer, not of a private citizen. The fact that...
What's wrong with, as I read Ms. Reinkoester's brief, she sort of says there's sort of two approaches that are applied, and one is the person engaging in the conduct objectively appear to be doing it as a parent or as a law enforcement officer, and the second is, did the person who's engaging in the conduct consult with the state or the police or have discussions with them before engaging in the conduct? What's wrong with those standards?
they're not very clear, honestly. And furthermore, they don't cover all of the other elements that that same case law covers, such as whether the individual was engaging in a legitimate private purpose, such as being a security guard or a mechanic and finding dope in the car, just in the course of their business. Especially in the second case here, first of all, the police were on the phone with Ms. Kilberg, and Officer Kilberg was telling her what to tell the police during the incident at the house when he went out and got into the trunk of the car. The police were involved. He told them at one point to get over there, and then he had to call back and say they didn't need to hurry because he had the kid had left and he had the contraband. The other thing about this here is the holding of the contraband is a big deal. In every case, there's a line drawn between finding something and calling the police and taking possession of it as a private citizen.
Does it matter that he wasn't the officer who booked Chris or who processed the evidence?
I think it's pretty much irrelevant, honestly, because he's the one who actually sees the evidence, stopped him, held him until other officers got there. He had, in fact, made an arrest.
In your view, what should this stepfather have done differently?
Well, interesting question. First of all, I think that there is a fair amount of intellectual dishonesty to say that a police officer has to turn in marijuana, but he doesn't have to turn in a gun, which a felon is in possession of. To say that it's a family matter to not report that your son's a felon in possession of a firearm is a pretty major omission, I think. So my view is that what should have...
So he should have turned him in or arrested him for the gun or turned the gun in as
Seems
well?
to me that in order to... He should have either, as a parent, flushed the marijuana, handed back the gun, and dragged him down to CADS, and probably done a civil commitment, or he should have been honest that he was going out there as a police officer and let his son know that if there was contraband, he'd be arrested. Clear, honest, transparency is, I think, the word that is bandied about a lot now. Transparency really helps it helps the reputation of police officers, and that's something we all need to bolster right now. And I think anything else I said would pretty much be repeating what I already said. If there are no further questions, I'll ask that the court find that the state, that Officer Kilberg engaged in state action in both incidents. Thank you.
Thank you, Ms. Phelps. And again, thank you, Ms. Reinkoester. The case of State versus Brown is now then submitted to the court. And I want to thank the students again for being a part of our day. And we hope that we've given you a little better understanding today of the role of our courts in our government and in advancing and ushering our collective belief in justice over time. You actually heard two very significant and interesting cases, electronic warrant case this morning, and then this afternoon the state action and the parental search resulting in the filing of criminal charges. I know you're probably interested in following up with the decisions in these two cases, and you can do that online, and normally it takes between 60 and 90 days for us to get the decision finalized, but you should be looking for it around that period of time. So, Mr. Dammel, thank you again very much, and I would ask the bailiff to adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.